Hello, good afternoon, and welcome to The Law. This is your legal light. It is your health law. The High Court has given a judgment in a very controversial matter, the Anti-LGBTQI+ bill, passed by Parliament, but still not law. The court said, among other things, that, quote, the cases before the Supreme Court concern the constitutionality and validity of the bill itself. There are two cases, one by Amanda and one by Richard Sky, which are in the Supreme Court. And that is what the judge is talking about here. She says, the cases before the Supreme Court concern the constitutionality and validity of the bill itself. Those cases are saying that the bill is unconstitutional and should not be passed into law. Therefore, it is my considered opinion that this application for mandamus is premature, as the essence of the very bill is being challenged at the Supreme Court, and it will be preemptory to grant the application. And she said that APAL, JSC, in the case of Republic versus the Registrar and President of the National House of Chiefs, Kumasi, and 4 others, 2019, Ghana Law Time Report, volume 49, held that mandamus will not lie where the demand is premature. This action challenging the constitutionality of the bill being first in time, one would expect that they are dealt with first, and depending on the outcome, the bill can then be presented and assented or otherwise by the President. After a careful consideration of the application, even though the applicant satisfied the court that there was a duty imposed on the Speaker and the President, per the reasons given above, I am not minded exercising my discretion in the applicant's favor, as I find that it is not appropriate at this time. I'm Samson Ladia Yanini. We'll be right back. You're welcome back. So this afternoon, relax, myself and my very good friend, Nii Kpakpo Samoa Ado of Ado Attorneys, will take time to digest the judgment of the court that refused to compel the President to accept the bill from Parliament and to indicate whether he will assent to it or he will not assent to it. Nii, thank you so very much for making time to join us.
Oh, Samson, it's always a pleasure to be with you.
Right. So on the 29th day of April, that was on Monday.
Yes.
2024, Her Ladyship Ellen Lordina Sewa-Mreku, Justice of the High Court, heard the application or the suit brought by Roxanne Nelson Echeke Dafeamako against the Speaker of Parliament and the Attorney General. And her decision, as in the decision of the High Court, is what I read to you a while ago. But as I bring Nii in, let me read the introduction to the judgment. The judge says, this is a decision on an application for judicial review made to this court seeking an order of mandamus to compel the Speaker of Parliament of the Republic of Ghana to present the Human Sexual Rights and Family Values Bill, hereinafter referred to as the bill, that was passed by Parliament on the 28th of February 2024, and a further order directed at the President to receive the bill and perform the duty imposed on him under Article 106, Clause 7 of the 1992 Constitution. I bring Nii in now. He is the lawyer who conducted this case, and our purpose this afternoon is simply to give you an education by explaining to you what the ruling is. But let's begin from our Law 101, which also touches on the subject of this process. Our Law 101 today is Article 106, Clause 7 of the 1992 Constitution. It reads, where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill or that he refuses to assent to the bill, unless the bill has been referred by the Speaker to the Council of State under Article 90 of this Constitution. Help our viewers to understand what this provision is talking about.
Okay, so typically, and as I said, I'm enjoying this part because it takes me back to my role also as a law lecturer at Ghana's Premier. Let me advertise my school, Gimpa Law School.
But we don't want to have a debate about when you say Ghana's Premier. I wanted to hear Premier what?
No, Premier in terms of the fact that we give quality legal education, you know.
Okay.
Let me slip that in before my D comes after me.
All right.
Now, you see, the issue is about what we call public law remedies and public duties. So all our public officials, i.e. the president, and this time when we are speaking towards the organs of government. So we have the executive, we have the legislature, we have the judiciary. And even anybody who occupies a public office, you are under an obligation to carry out your mandate in accordance with the instrument that creates your office. Now, it's even more special when it comes to the Constitution, because the first point is that the Constitution is the supreme law of the land. So we have this enshrined in Article 1, that anything, and we call it the ground norm, we call it the basic law, the most important law. What is important for our viewers is that everything that is done within our public space or within this country must conform to the 1992 Constitution. So all laws, all conduct, everything that we do must be in accordance with that. So we have the concept of the supremacy of the Constitution. We don't have, unlike in the past, or if you look at, for example, if you look at the UK, you will see that we have, they believe it, they have, even that has slipped a bit, but they have the sovereignty of Parliament. Yeah. But we have the sovereignty lies in the Constitution. So the Constitution is supreme. We go alongside the American democracies and other side governments who have a written Constitution, which basically then becomes the basic law of the land. And so everything that is done must be in accordance with the Constitution. And for organs such as the presidency, Parliament, the judiciary, everything that is set up by the Constitution, you must conform to the constitutional provisions. So where the Constitution has delineated or said that you shall do A, and the word, especially when the word is shall, in interpreting our Constitution, we say that everything that has shall is mandatory.
That's right.
So there's no discretion in the matter. You must conform unless the courts come and say that, well, in that situation, the shall is may, which is allowed under certain circumstances. So people may recall the election petition, where even though there was a provision that said the presiding officer shall sign the form, the Supreme Court is given that
famous pink sheet.
Yes, the unique opportunity to decide what the meaning. So we have given the Supreme Court the sole prerogative to interpret and enforce the Constitution. So when it comes to duties assigned to any of the organs of government, and specifically to persons such as, in this instance, the President and Parliament, they must comply. And so where the administrative work or in doing those things, a public officer either refuses or decides by omission or commission not to do that particular act, there must be a way by which we can enforce or compel that person to perform that duty. And let's break it down. If, for example, in your area, your district assembly is not collecting your rubbish, for example, and this one, so that you don't think that, oh, this has to do with only constitutional bodies. Even when you don't, the district assembly in your area is not performing its duties, such as checking the illegal building of putting up of structures and all that. You can actually go to court to compel your district assembly to perform its duties so far as those duties can be found under the Local Government Act, for example. So anytime, electricity, water, you know, Ghanaians, we don't litigate or we are getting there. But in other jurisdictions, where you don't perform, maybe I'm attending a public school, there are certain expectations, and those expectations are not being met. You have every right to sue the public body responsible, your roads, for example. The roads, instead of going to a demonstration, maybe you should think about it. Go to court. Let the person who is in charge of that public duty realize that you have a right at law to compel that person or that body to do what, if you can find it within the law.
Duty imposed by
law. A public duty.
On the public official.
Or public official.
And they refuse to do them.
Refuse to do it.
You are allowed to go to court, as you did in this matter, by way of seeking judicial review in the nature of mandamus.
An order to compel. What this decision, and even that I must commend the judge, has elevated is in respect of the fact that when it comes to a constitutional duty, you don't need, and we'll go through the mechanics. We'll get there to
the first thing I needed you to do, first you are giving us education on how to, as it were, go to court to compel somebody to do what they are supposed to do.
Correct.
Once it's a public duty imposed on them by law. But before we get into the details of that education, the article we referred to says where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill or that he refuses to assent to the bill. What does that mean?
Okay, so there's, in under Article 106, Parliament has, basically we all know that Parliament passes laws. And the Constitution has provided the method by which it will pass the law. What is important, after they've gone through all the motions to pass the law, the debate, going through the committee stage, they would come back to it, they will lay the bill, it will go through a first reading, to go to a second reading. The MPs are even best positioned to educate us on all that. And the most recent case we've had on that was the issue of the budget. So after they've gone through all that, there's a formal process by which it moves from Parliament to the President. Because remember that Parliament's duty is to legislate, but they don't bring a law into being. It is the President who is given the prerogative of what we call formally assenting or signing the bill into law. So Parliament will pass the law, they would make the necessary copies, they would then, by formal process...
But it still remains a bill. It doesn't become a law.
It doesn't become a law.
It only becomes a law if the President puts his signature on it. And this is where we are.
This is where we are.
With this LGBT, what we call anti-LGBT law.
Bill. Okay. So in this situation, the facts as they are that Parliament completed its work, and both sides agree, because when we filed our processes in court, there was no dispute about the fact that Parliament had come to an end in terms of what it had to do. So we call an admission. When we filed and we pleaded the facts, the Learned Attorney General's Department also agreed that Parliament had completed its work. What was left was the fact that Parliament now, through the Clerk of Parliament, had transmitted the bill to the President's office.
For his signature.
Now, we have a letter from the Secretary to the President. I don't know whether you have it up.
Yeah, we have it. People are familiar with it.
Okay, so they moved the letter to the office of the President And the office of the
president, the famous seize and
desist in an American term mostly used.
So the secretary to the president had written a letter to the clerk and sought to tell Parliament that they should cease and desist from trying to present the bill to Parliament. And as we understand, to the presidency. As we understand, they had attempted to take the bill to the presidency for about 2-3 times. And it was not being accepted.
Correct.
So they had to write a letter to caution that they should cease and desist from trying to bring the bill to the president to sign. And they gave their reasons. And Nii is continuing with that.
So they gave the reasons, and the reasons basically being that 2 Supreme Court cases were pending with interlocutory injunctions applying. So based on the fact that those 2 bills were pending, those 2 suits in the Supreme Court were pending, the presidency was of the opinion that based also on the advice from the Attorney General's department, they could not accept it because part of the reliefs being sought was in respect of whether or not the bill, some of the reliefs being sought was to prevent Parliament from transmitting the bill to the office of the president and also challenging the constitutionality of the bill itself, whether it had been properly passed or not. But what the letter hinged on was the injunction applications pending. And therefore, of course, if there's an injunction application pending, the opinion of the Secretary to the President, backed by the advice from the Attorney General, was that they could not present the bill. And they had to wait for the injunctions to be determined before they could present the bill to the presidency. And later on, there was a letter from the Clerk of Parliament to the Office of the President saying that they are taking note of what they had said and they will therefore wait for the presidency to signal to them whether now it was an appropriate time for them to proceed to present the said bill.
Right.
Based upon that, Mr. Roxon, my client, who is also a member of Parliament, felt that no, what had gone on was not constitutional because the 2 bodies, that is the Speaker of Parliament, and to a lesser extent, the Speaker had sent the bill, so we cannot say he didn't try. But even the Speaker of Parliament and the presidency did not have a discretion in this matter. That was
whether they will accept
it or not accept it. You understand? Unless there is a court decision. You understand? Because we also have to police, and as I said, the members of Parliament and generally as citizens, we have to police the Constitution. And that is how we grow and develop our constitutional dispensation. When we see, feel, think that somebody is, in fact, the Constitution imposes a duty that when you think that something is either against the Constitution by either an act or an omission, you have a duty to go to court to challenge it so that the court, the Constitution has given the exclusive jurisdiction in respect of challenging constitutionality of actions to the Supreme Court. That is, if you feel that the act that is ongoing or is about to happen or has happened or in respect of whatever it is against a constitutional provision, then you go to the Supreme Court to either interpret or enforce or have a declaration to that effect. However, in respect of public duties, the lower court, that's the High Court, has jurisdiction. So the first point and the basic point always is that every court is a creature of statute. Every court's powers to enforce or to sit is guided by either the Constitution or some piece of legislation or statute. The courts don't just exercise jurisdiction because they are courts. No. They exercise their jurisdictions based on specific legislations. So in respect of the public law remedies, where it is about a public duty, an administrative duty for that matter, such as taking a bill, you understand, from A to B, that's an administrative duty. Or signing the bill, which is the duty of. And remember that the president is not, you are not going to court. In this case, we'll come to the reliefs. We didn't go to court to force the president to sign the bill. You can't do that.
So let's read the reliefs.
Yes.
You had taken the application, and this is what you were seeking from the court. 1, a declaration that the Parliament of Ghana duly complied with all constitutional provisions stipulated in Article 106, 1, 2, 3, 4, 5, 6, and 6 of the 1992 Constitution of Ghana, in the passage of the Human Sexual Rights and Family Values Bill on the 28th of February 2024. So 28th February, that's when Parliament
completed its work.
Indicated to us that they had finished passing that bill or making that law. 2, so you are saying that the court should make a declaration that Parliament complied with the laws that it's supposed to comply with to, as it were, pass that bill.
That the legislative process had come to an end.
Right.
Because it's important to note that if the legislative process hasn't come to an end, then there will be no duty to send the bill.
All right. 2, you ask for an order of mandamus directed at the Speaker of Parliament, that's first respondent, to present the Human Sexual Rights and Family Values Bill to the President of the Republic of Ghana in accordance with Article 106, Clause 7, which we have shared with you a while ago, on the basis that the Parliament of Ghana has duly complied with all the constitutional provisions which it needed to comply with to pass the bill.
Exactly.
3, you ask for an order directed at the President of Ghana after
presentation.
Speaker has presented.
As the Speaker has presented.
To signify his assent or otherwise within 7 days to that bill.
Yes.
4.
In accordance with the provision of the Constitution. So the 7 days is not our mandatory provision. It's actually in the Constitution.
Right. The provision we have shared with you. 106 Clause 7. 4. An order directed at the President of the Republic of Ghana to signify to the first respondent, that is the Speaker.
Correct.
Within 7 days after the presentation of the Human Sexual and Family Values Bill, his assent to the bill, or that he refuses to assent to the bill in accordance with Article 106, Clause 7 of the 1992 Constitution. And finally, any other reliefs that the court may deem fit.
Yes, yes. So basically that was, so we were in court in accordance, because now under the law and the rules of court, it is only the High Court that can deal with an issue with respect to the mandamus when it comes to this kind of application. We couldn't go to the Supreme Court to seek a mandamus in respect of, because the Supreme Court does not have an original jurisdiction when it comes to such an application. You need to come to the High Court for such an order. So then the High Court is governed by a particular rules set out by the Rules of Court Committee. That's a bit technical, but it's in our rules to how we should proceed with the said application. So that is what we invoked by way of bringing the case to court. We were in court, 1, to say that, look, everything that Parliament has to do has been done. Number 2, the Speaker of Parliament is under a duty, pursuant to this section, to carry the bill from Parliament to the presidency. 3, the President also has a duty to either sign the bill or to tell us that he will not sign, and then refer it to the necessary bodies that are in the Constitution, so that the process of legislation does not come to a standstill. Because there is no choice.
So the Speaker had already attempted through the clerk to submit this bill to the presidency. Why are you asking the court again to compel the Speaker to take the bill to the president?
Okay, so the reason behind this is this. When it's now a court order, you can't refuse it, because then when you refuse it, there's a sanction attached to it. Remember that the president, if there's an order, he cannot refuse the order. The president is subject to the Constitution. So the compulsive nature of the order was what was going to change the dynamics now. Because now it was as if these are two public bodies. One says, I have a discretion. Everybody was interpreting, especially the presidency, was interpreting the law in accordance with what they believed should be. And once there's a dispute, we have all decided that we are in a democracy. And so when you have a dispute, citizen against government, government against arm of government, even the arms of government clash. So when it's a citizen against an arm of government, and the citizen believes that, as in my client, believes that, and remember, he was one of the sponsors of the bill. So he had an added interest to ensure that this bill was carried through. He also felt strongly that there shouldn't be a precedent. You see, sometimes the precedents we set now become, remember that our laws are also made up of precedents, customs, usages, and others. If we have this as a precedent, next time, somebody too will come and say, well, I have a discretion whether to accept this bill. Wait, let me. So we wanted to ensure that we have legal interpretation on this particular matter.
So first make a declaration that
yes.
Parliament has fulfilled everything it has to fulfill to make this law.
Correct.
Number 2, compel the Speaker to take the bill to the President.
So that he has no discretion. He cannot.
Number 3, compel the President to accept the bill.
Yes.
And if he accepts the bill, he would then be under obligation and
correct.
duty constitutionally to indicate whether he will assent
it. Because the time will start running.
Or he is not going to assent it and then follow the processes in the Constitution. So,
for example, let me give you an example. If the court had agreed with us, we would have picked up a court order, got a bailiff of the court to go with the clerk of parliament to go to the presidency. Now, once you have a bailiff of the court there, the presidency could not have refused to accept the bill. Because then if they do that, that would be contempt of court. Okay. So the dynamics could have changed completely if the court had agreed to give us the order.
So in the end, this is what the parties together with the court agreed was going to be determined.
Yes.
What we call the
issues.
1, there were 2.
Yeah.
Whether the applicant has made a case for the grant of the order of mandamus.
Correct.
Whether your client
had
actually satisfied the court that the court must issue that compelling order.
Yes.
And 2, whether this is an appropriate case for which the order of mandamus will be issued.
That's where it gets interesting.
So 2 things.
Yeah, that's where it gets interesting.
Whether you have satisfied
the conditions,
the conditions.
The legal requirement.
Exactly. And 2, whether this is an appropriate situation where this will be done.
Okay. So this is
what did the court say?
So
these 2.
Yes, so this is where it gets interesting.
Right.
Now, in such a situation with the mandamus applications, you must actually satisfy conditions, especially when there are 2. And with this case, we now see that there are 2 levels. Yeah. There's the one that where the public body has a statutory duty. And there's one where it's a constitutional duty. Where it's a statutory duty, you are bound by the long-held case laws which have laid down the basic, and the most famous one, recent one, 2012, the case is for our students of law and practitioners, Republic versus High Court Accra, ex parte Attorney General Ohene Japan interested party, 2012 to Supreme Court of Ghana Law Report 1204. This is on page 8 of the ruling, where the court said that the courts have over the years developed, quote, the courts have over the years developed a set of grounds when proven can found an application for mandamus, apart from the time limit of 6 months. So you must also bring the application within 6 months of the occurrence of the event. And there's also rules about the time, how we calculate the time, but that was not an issue here. The grounds to establish as follows: 1, that there was a duty imposed by the statute upon which he relied. 2, that the duty was of a public nature. 3, that there was a right in the applicant to enforce the performance of the duty. And 4, that there had been a demand and refusal to perform that public duty enjoined by the statute.
All right.
So that was one of the grounds heavily canvassed by the Attorney General's Department to say that we hadn't met these grounds. Because there was the belief, their argument was that we didn't have any right enshrined in the Member of Parliament. It is enshrined in the Speaker of Parliament. And so we had no right that we were seeking to enforce under the law. We had not made a demand because we didn't have the right so to do, and there had been no refusal. So we even had to write to the president, and the president should have refused before we could activate the legal process.
So the thing to note here by way of some education is that, as Nii has said earlier, if someone in the public or public office has a duty imposed on them by law to do something and they are refusing to do it, you can go to court by way of a judicial review application in the nature of a mandamus to compel them to do that public duty to you.
Yes.
The court says before you can come to the court and ask that that person or that institution should be compelled to do the duty which they have not done, you must have first made a demand on that public officer or entity, and they must have refused to perform that public duty. Then you can come to the court and say that this person or this entity was supposed to do this duty which is imposed on them by section this of this law or this provision of the Constitution. And I went and asked them to do it. There's a letter showing that I requested that they should do the job, and they have not done it.
Yeah.
It is only then that you can come to the court. So he gave examples initially that if someone has to perform a certain duty or district assembly and so on, and they don't do it, you can't just get up and walk to the court to ask the court to compel them. You must do the first thing. Ask them to do it.
In writing.
In writing. If they refuse or fail to do it, then you now go to court and say, we have asked, we have demanded, they have failed. Now it is only the court that can compel them to do that job.
Yeah.
Right. The court said, by quoting another decision,
yes,
the court said, these conditions must be strictly complied with prior to the grant of the order.
Yeah.
Thus, before a court would make such an order of mandamus to compel a public officer to perform a public duty imposed by statute or the Constitution on the said officer, the aggrieved applicant must satisfy the four conditions above. Remember, the four conditions once again are: 1, that there is a duty imposed by a law on a person to do something, or an institution to do something. 2, that the duty was of a public nature. It must not be private.
Yes.
It must be public in nature. 3, that there's a right to you to enforce that duty.
So let's give an example.
The performance of that duty.
So let's give an example. You can't go to court for a mandamus to compel a private school to open.
Yes.
You understand?
Right.
But you can go to court to compel a public school to open.
Right.
Aha.
Then 4, that there had been a demand and a refusal to perform that public duty enjoined by statute.
Yes.
The court said all this must be
Met.
fulfilled.
So now the next point the court then was to examine whether we had met the criteria. And the court made very interesting. That's where it gets interesting. Good education for all of us involved in the practice and the use of the law. So what the court said was that what the applicant is seeking in this court is an order compelling the Speaker of Parliament to present the bill, which was passed on 28 February 2024, to the President of the Republic of Ghana, and a further order directed at the President to accept the bill and comply with Article 1067 of the 1992 Constitution of the Republic of Ghana. The law is that the applicant ought to establish that the Speaker and the President have a public legal duty to act. The duty must be owed to the applicant, which was Mr. Roxon, and the duty is imposed by either a statute or a constitution. Right. Now, the applicant, again, the court said.
So can we say that in this decision,
yes,
you satisfied your client, Roxon
yes,
Dafiamapo, satisfied?
That's actually where we are getting. That's where we are getting to quickly.
Okay.
So the applicant contends that the Clerk of Parliament attempted to present the bill to the President on the 14th of March 2024, but he received a formal letter dated the 18th of March 2024 from the Secretary to the President asking him to desist from transmitting the bill to the President because the Attorney General had, by a letter dated the same 18th day of March 2024, informed that the President it would be improper to receive the bill from Parliament pending the determination of the two injunction applications filed at the Registry of the Supreme Court and which had been served on him. He further contended, that is Roxon, that the Speaker of Parliament, the Clerk of Parliament, and the President are all public office holders and are subordinate to the Constitution. And as such, this court should compel them to perform the constitutional functions as Parliament has complied with all the provisions of Article 106 of the 1992 Constitution, and there's no other effective remedy to the relief sought. To discharge the burden placed on him to establish that the respondents have a public legal duty to act and that duty is imposed by statute or the Constitution, The applicant brought the application under Article 106, and then the court goes ahead to tell us what we have already set out on Article. Yeah. The above article, so this is the court. Yeah. The above article imposes a constitutional duty on the Speaker and the President as they are required by the provisions of the article to perform some functions. Yes. That is, for the Speaker to present the bill that has been passed and the President
to assent or refuse to assent.
Exactly.
Or make a referral under
Article 190. This function is an administrative one. And this duty is imposed by none other but the supreme law of the land, the 1992 Constitution. The Speaker of Parliament and the President of the Republic of Ghana are both public office holders. Right. See Articles 295 and 285 of the 1992 Constitution. The act complained of by the applicant being an administrative action of a public office holder and such as the Speaker and the President, and being imposed by the Constitution, this court has jurisdiction to entertain it, which was very significant because there was, and even the next provisions, the next statements by the President was, the court was even more telling for me. The provision in Article 1067 of the 1992 Constitution means that after, then it went through it goes through the,
let's talk about how the court considers the letter that was sent. The court said, for example, that I am of the considered view that these letters are not an act of outright refusal, but a request to hold or postpone the performance of the duty to a later time. So the court is saying the President did not refuse to accept the bill. What the President did was to say, let's hold on. Because there are two cases in the Supreme Court. Those cases happened before this thing that you have drawn.
Exactly.
Right.
Now, it also says that, lastly, for the right to an order of mandamus to arise, the applicant must have inter alia made a demand and same be refused or deemed to be refused by the public officer before a party could proceed to court. Then it made the distinction between a refusal, because if the court, and let me conclude and I'll show the distinction. It should, however, be noted that the current law in Ghana is that the demand and refusal rule, which is the general rule, is only applicable to statutes and not to the Constitution. And then he gave a decision.
Therefore, the applicant did not need to make a demand on the Speaker.
Exactly.
And the President, before bringing the present action, as the duty complained of is one imposed by the Constitution and not a statute.
And I think people would want to know that authority.
So the distinction is important.
It's very important.
That we have actually educated the public now that if a public officer or a public institution owes a duty to you which is of public nature to perform, and they don't, the first thing you do is that you make a demand on them. If they refuse to still perform the duty they are supposed to perform,
remember, you must have a right.
Then then you go to court. But the court is saying here that if that duty is imposed by the Constitution and not some other law, then you don't need to make a demand. You can come to court straight. Good.
And the case is Labi Mensah IV, alias Ayi Adokwe versus the National House of Chiefs and another, 2011 to Supreme Court of Ghana Law Report 883.
Right.
And from the above, it can, so this is where the court concluded. From the above, it can be seen that the first and the respondent and the President of the Republic of Ghana owe a public legal duty to act. And the duty...
The Speaker and the President.
They owe a public legal duty to act. And the duty is imposed by the Constitution. Therefore, the
President, being a member of Parliament
and a Ghanaian, can bring this present action for the release he's seeking. And I'm therefore satisfied that issue 1, as raised by the court, which is whether or not the applicant has made a case for the grant of the order of mandamus, is answered.
So you have succeeded on the first leg.
Which was the legal ground. You understand? So if this was only based on satisfying the legal requirements and that the court did not have any discretion, the court was under a duty to have granted it. But the thing about mandamus application and public law remedies is that, yes, there's a legal requirement that you must satisfy, but it is also discretionary.
But of course, the discretion must be exercised judicially.
That is the
and you will find here that it was so exercised judicially.
Yes.
Right. So the first leg of the issues that were set down in this case, your client won because the court granted that.
Exactly.
The president and the speaker, they are public officers.
Yes.
They have a public duty. First, speaker to send the bill and the president to accept the bill and to signify that he will assent or that he will not assent for whatever reasons.
So if there is no intervening reason and the facts are as they are, then the mandamus will lie.
Right. So you have succeeded on that. How about the issue 2?
Now the issue 2 is also very legal, and everybody must understand
whether or not this is an appropriate situation where the court will grant you the compelling order
or not.
Okay.
So yes, you satisfy the legal requirements that you have a right. The persons involved are under duty to act. They did not act. They have not been acting, or they have not acted. So you are in court. The court is satisfied that it has jurisdiction to so adjudicate over the matter.
Right.
But the courts and the laws and the rules, in its wisdom, still grant the court a certain it's a discretionary remedy. It's not as of right, because there are certain situations that yes, you may have a legal right, but there are certain intervening events.
So the court was clear on that and said this.
Yes.
I would now turn my attention to issue 2.
Exactly.
Which is whether or not this is an appropriate case for which an order of mandamus should be issued. In stating the applicable law, I stated that the issue or order of mandamus is granted not as of right.
Exactly.
It is discretionary.
Exactly.
So, though the conditions for grants as stated above may be made out by an applicant, you may have satisfied the conditions. The court may refuse to order may refuse to order it for justifiable reasons. So now we're going to see how the court shows the justifiable reasons for which
it's decided not to. So now the court picked our first relief, which was that we had asked for a declaration that the Parliament had passed the law in accordance with Article 106, all the necessary provisions.
Right.
Now the court was of the opinion that one of the cases in the Supreme Court,
actually both,
both, yes, but it laid its emphasis on one of them. That one of them is touching on whether or not the law as passed was passed in accordance with the constitutional provisions. And remember that it is only the Supreme Court that can decide on that particular matter.
Right.
So in its wisdom, it says that, look, if I were to give the order and to grant you the order for mandamus, and then later on down the line, the Supreme Court comes out to say that this decision, that the bill was not constitutionally passed, it means that its decision, that's the High Court's decision, will be rendered nugatory automatically. And so, in its wisdom, and you may disagree. Yes, we disagree. The party says we disagree with that portion of the decision.
The court said there are 2 suits.
Yes.
The first suit was filed in May 2023.
Correct.
And the second suit was filed on the 5th of March 2024.
Right.
And the court said both cases have invoked the original jurisdiction of the Supreme Court. The plaintiff in the first case is claiming that the Speaker of Parliament has breached Article 108 of the Constitution by failing to ensure that the provisions of that article was complied with in the passage of the bill, and thus the entire process relating to the bill is unconstitutional and void. It says the second case is claiming that the passage of the bill by Parliament contravened the Constitution, as some constitutional provisions were breached. As such, it is to that extent null, void, and of no effect, among other reliefs.
Right. So that is where the court focused on. Now look, what is important is that the court said, yes, I have jurisdiction. I can give the order. But I have a certain discretion, and I have to evaluate. If I give you this remedy, and later on the case in the Supreme Court the court rules that indeed the
Parliament did the wrong thing.
Did the wrong thing, it means that my order to compel this process to move on would be rendered nugatory.
Right.
Because the bill itself would have been declared a nullity.
And the court also said that your case came after those cases in the Supreme Court. So the Supreme Court should be given the opportunity to determine whether Parliament did the right thing or wrong thing before there can be a mandamus. If the Supreme Court holds that Parliament did everything correct,
then you can come back.
Then you can go back and say
you can come back.
That the president should pass it.
If the president is
should
so, for example,
it.
if tomorrow Parliament, the Supreme Court sits on this matter and makes a declaration that everything was fine and throws out these two rates, you can actually go to court the very next day on the back of that decision and say that then the president must necessarily, Parliament must move the bill, the president must. So everything is now...
That is if the Supreme Court rules that way,
yes,
and the bill is being sent and the president, or the bill is not sent at all.
So now...
Or that it is sent and the president still says that he will not accept.
So my understanding...
Of course, there will not be any basis for
but my
not
understanding of the law now is that if there is a public duty to be done, and it's a constitutional duty, and you have evidence that it has not been performed,
right,
you don't wait.
All right.
So if you go, for example, the famous case involving the EC having to do this ROPA.
Diaspora voting.
Exactly. So if you go to court and the person runs to court and say, I've done it, that ends the matter. So actually it is good for those in the space of public law litigation that when it's a statutory duty, you don't have to wait for anything. You don't even have to have a right to them. They refuse.
And the judge says your application is premature. Premature because those cases are pending.
They are pending.
And it is only the Supreme Court that has the power to determine the constitutionality or otherwise.
Okay. Where we disagree, let me put that as a caveat, where we disagree is the exercise of the discretion.
That's right.
So that is Roxton, is at the Court of Appeal, seeking to challenge whether the discretion was exercised rightly or wrongly.
That's why the court concluded that I am not minded exercising my discretion in the applicant's favor, as I find that it is not appropriate at this time. It is not appropriate at this time.
So there's always
That is how this case before the High Court was lost. We're opening the phone lines. You can join us with your questions to Nii Samoa Addo on this particular subject that has gone to the court and has been determined. What this simply means is that now we all must abide what the Supreme Court will say on the two cases by Richard Sky and Dr. Amanda. Is it Kofi?
Kofi, yes.
Yes, okay.
But of course, if the Court of Appeal decides to reverse this decision...
The Supreme Court?
If the Court of Appeal reverses the High Court decision, then we are back.
Okay.
Yes.
You said if. Doesn't mean there's an appeal to
There is an appeal. There's an appeal that has been filed.
Okay, but this is sound.
Yes. The second part
what should the Court of Appeal be saying?
The discretion is where we say that the discretion should have been in favor of... Because I give an example. If the bill for the budget, the annual appropriations bill, is passed, and somebody goes to the Supreme Court and says that for whatever reason the appropriations bill is unconstitutional, are we saying that for the length of time that the Supreme Court is going to take to determine the constitutionality of the appropriations bill, Ghana's appropriations will come to a standstill?
But that's a different thing from this one.
It's the same issues.
They look like two sound reasons for exercising the discretion.
It is,
against granting an order of mandamus against them. So because number one, it says that clearly the constitutionality of the bill has been challenged. Whether the Parliament complied with the law to pass it has been challenged.
Correct.
Number two, it is only the Supreme Court that can pronounce on whether something is constitutional or it is not.
But in the same decision also, the court said...
You can call us to ask your question.
Is it in the same decision, the court...
Right. Mohammed, you are calling us from Tamale. Let's hear you.
Good afternoon,
Hi.
I think this is very, very engaging, but my simple question is, at at what time is the Supreme Court supposed to call cases which is of national interest to the citizenry? Because these two cases that have been pending at the Supreme Court, we always admit to the fact that it is of very important to determine issues of anti-LGBTQ law, which is at the last to the extent I want what is the scope of interest people are facing.
Okay, thank you very much, Mohammed. So, are there timelines?
You have the access to the higher body. So maybe you invite the registrar of the Supreme Court.
Which higher body? So explain. This is how it works. When you file a case before the court, there are timelines within which the case will be gone into. In the Supreme Court, once you file it, we have a process. And that process is actually going through now. So we have to wait for it to go through. Of course, there have been some delays in many situations, but sometimes the delay is actually not blamable on the court. Asamoah Yao, you are calling from Kumasi. Let's hear you, Asamoah.
Well, my comment is this. The whole process has an ulterior motive from somewhere. For example, Parliament is the only institution in the country that passes a law, this most supreme law in the country. You cannot ignore the supreme laws of the country by any means. And I'm thinking that the president, the Kufuor, is not signing that he, whatever,
Asamoah, we have sought to give you some education here, which ought to be basic to you. It's a constitutional matter. Hello, Asamoah. Parliament does not have the power to complete the process of law making. They will make the law, but for the law to become law, that will be binding on all of us. It must have a president's signature. That is where we are. So you cannot say Parliament has made a supreme law. It is not law yet.
I don't. No, I don't think you heard my point. Please, I'm sorry to interrupt you. My point is that the president, the chief executive, is refusing to sign it because it's right now a state interest.
But there are two suits in the Supreme Court challenging the constitutionality of that law. How do you expect the president to sign them now when they are being challenged?
Do we have a precedent? Do we have a precedent in the parliament for a president refusing? Do we have a precedent for a president refusing to sign a publicly agreed law? The president has a personal, private, or family motive.
Okay, Asamoah, thank you very much for your intervention. On the law here, we try to take away the politics, and we try to stay on the purpose of education, to educate you on and about the law. I may be able to take one more call before we end this. But that's Arimia, you are calling from Savligo. Let's hear you.
Wow.
Good afternoon, Mr. Kpakpo.
Good afternoon. Let's hear you.
I wanted to know whether the bill is being sent to president or not yet.
The bill has been sent to the president. The president has refused to accept it because there are two cases in the Supreme Court challenging the constitutionality of the bill. And there are also injunction applications against the speaker sending the bill and the president accepting the bill.
Okay, well noted. It means that Mr. President did not refuse to sign the bill because the bill is not even get to his table for him to sign because of the suit pending on the Supreme Court. Is that not so?
Yes, so as we speak, the bill is not before the president because he has not accepted it.
It means that those making allegations against Mr. President is false, or they are not even educated on the particular matter.
All right. Thank you very much, Amiria Arimiyao in Savalogo. Thank you. Yes. So,
interesting.
What's the thing? I think we said that before we ended.
Yeah.
Now we can only wait.
And I was saying that. Well, but we are still interested in testing the decision. Because, of course, the higher you go, the better it is for you to test the grounding of the decision.
Right.
So we will test it in the fairness of the Court of Appeal and see how it comes out.
Right. But the basic education you want people to take about the exercise of the supervisory jurisdiction of the court is that, repeat that again.
For me, it's simple. One, if it is a constitutional duty, if you are dealing with any of the constitutionally established bodies, or if you are dealing with something that has to do with an exercise of a constitutional duty under law in the Electoral Commission, National Commission on National Commission on Civic Education, any of the bodies, armed forces, the Ghana Police, all of these bodies are set up by the Constitution. The Bank of Ghana, the Statistics Service, all the bodies that you can think about established by the Constitution. You don't even need to write to them to ask them for something and they refuse. If it's a constitutional duty, you can go to court. But for all the other statutory bodies established by statute,
if there's a law that says you should do something, it's their duty to do it. And they don't do it. You write a letter.
And
say you haven't done this.
Exactly. Or you go and complain. At least have the evidence so that your lawyer can be able to present it.
If they don't do it, you go to court. And the court can issue a mandamus to compel them
the person
to do their job.
Public duty. So long as it's a public duty, not a private duty.
Right. Thank you very much. And my guest has been Nii Kpakpo Samoa Ado of Ado and Ado Legal Attorneys. He's also a law lecturer. This has been the law. It's your legal rights. It is your help law. I'm Samson Ladia and have a good afternoon.